Thank you for joining us for our presentation on the EB2 National Interest Waiver. My name is Dustin Saldarriaga, and I'm a Senior Associate at Scott Legal PC in New York City. And I am joined by my colleague, Jiyae Hwang, a fellow Senior Associate who has extensive experience preparing EB2 National Interest Waivers, as well as a variety of other green card options. Our firm does focus on business immigration, though it is important for me to emphasize that we do handle the full spectrum of U.S. immigration law. So we handle family-based green card applications. We handle temporary visa options, including options for entrepreneurs such as the E2 and the E1, options to come to the U.S. to work temporarily, such as the H-1B, the TN, student visas, visitor visas, really, again, the full spectrum. So we really do hope that you will reach out to us if we can be of any assistance to you. Something that really does make our firm stand out is the fact that our founder, Ian Scott, has personally navigated a number of visa options, including the F1, the H-1B, the TN, and now the E2. So our firm was actually founded and is currently based on an E2 visa. So the fact that Ian has personally navigated the process really does inform how we work with our clients. The E2 will not be the focus of this presentation, but if you are curious about the other visa options, do take a moment to visit our YouTube channel, Scott Legal PC, where we post full-length webinars, including this one. This webinar will be recorded and posted to our YouTube channel. And we also post shorter videos. And again, those run the full gamut of US immigration law. So check those out, as well as our blog. So our blog is extensive. We are constantly posting new articles. So we do hope that you'll take advantage of that and find that information helpful. After this presentation, we'll be sending you a link where you can find our blog as well as our YouTube channel. We will also, we'll send you an email. That email will also have a copy of the PowerPoint presentation that you see on your screen, as well as a link where you can sign up for future webinars. And again, those do run the full spectrum of US immigration topics. Jiyae will be speaking on some topics in the later half of this presentation. We will be taking questions. We'll likely save those for the end of the presentation, but don't hesitate to send those in using either the question and answer function on Zoom or the chat function. We'll be monitoring those, and again, we'll probably save those for the end, but we do hope that you'll send those questions in as they occur to you. So without further ado, let's go ahead and dive in. So again, the focus of today's webinar is the national interest waiver. So this is a subcategory of the EB2 green card. So EB is employment-based, meaning that it is a work or a profession-based green card as opposed to a family-based green card. It is in the second preference category of employment-based green cards. The category or the subcategory of the EB2 that we will not be talking about today is what we call the perm-based EB2. And that is where you find a US-based employer who is willing to sponsor you and go through the process of labor certification, advertising the job, making sure there's not a qualified and available US worker. It really is a time-consuming and extensive process for perm. So that is why the national interest waiver that does not require that is particularly attractive to people. So again, today we're focusing on the national interest waiver, which does not require that the employer go through the perm process. And of course, because this is a green card, if you are approved, you do receive permanent residency in the United States. You get a green card. And if you hold that green card for 5 years, you do become eligible for to apply for citizenship through the naturalization process. So that is quite, for many people, an attractive option, though if citizenship is not your goal, there's no requirement to apply for it. So let's talk about what the national interest waiver is. I just gave you a bit of background, but let's go a little more into depth. So it is a green card option that is available when the US government agrees that you are coming to the US to do something that is in the national interest. We'll talk about exactly what that means. It should not be too intimidating of a term, though. It does carry some weight, and we'll talk about exactly how. So again, the NIW is a subset of the EB2 employment-based green card category. The national interest waiver has a 3-requirement test, and we will talk about each of those 3 requirements later in the presentation. They are based on a recent case decided within the last 10 years called Danisar. And Danisar, we in the immigration legal industry, we see Danisar by and large to be a very positive case. So we'll talk about why that is. One of the reasons is that it does introduce these 3 criteria for qualifying for a national interest waiver. It does make clear as well that the national interest waiver should be accessible. It is not supposed to be a green card option that is just, so difficult to receive that very, very few people receive it. It is a green card that obviously is not accessible to anyone, just anyone, but if you satisfy the requirements, should be accessible. And one of those categories of applicants is entrepreneurs. So Danisar made it explicit that entrepreneurs can and do qualify for the national interest waiver. So for our clients who are on temporary visas, such as the E2, where they're in the US, they are pursuing their own business, developing and directing their own business. When they come to us and they say, my E2 is going very well, I think I may want to pursue a green card. What green cards do I qualify for? The EB2 national interest waiver is typically one of the key options we consider, along with the EB5. And we do have presentations on the EB5. We won't be talking about that today. You do not need an employer to apply for a national interest waiver, and this is key. So I said before that there is a subcategory, the PERM subcategory for the EB2, that does require an employer to sponsor you. The national interest waiver, you as an entrepreneur can apply on your own behalf. So what is required is that you have a proposed endeavor, and that proposed endeavor does not require that you have an employer in the US. You can be coming to the US to pursue your own endeavor. And so that is key. So you can what's called self-petition for a national interest waiver. So why do we call this a waiver? Why is that in the title national interest waiver? That's because the waiver that's being referred to is a waiver from the PERM process. Again, that is the requirement to advertise the job to US workers, and if there is a qualified and available US worker, that they be offered the job opportunity before it's given to a foreign national. That requirement is waived for the national interest waiver, assuming you are approved for the national interest waiver. And we'll go into more detail on that requirement later in the presentation. And finally, applicants in any field can apply. So again, the national interest waiver is not just for entrepreneurs. It can be for scientists, researchers, it can be for doctors, physicians, and can be for entrepreneurs, can be for people in business, can be for people in the arts as well. So really what is important is defining the proposed endeavor that the person will be coming to the US to pursue, as well as showing in the application how that applicant satisfies the requirements. And speaking of which, we will get into those requirements right now. So to start off, when we're talking about the national interest waivers requirements, the first thing that you need to satisfy are what we call threshold requirements. Why do we call these threshold requirements? If you don't satisfy these threshold requirements, you don't proceed. The government is not going to look at your proposed endeavor. It's not going to consider whether what you're going to be working on is fundamental to the survival of the United States. It's not going to care if it's in the national interest or of substantial merit. You need to satisfy these requirements to get to that later stage. So what are those requirements? You need to either have an advanced degree, which is defined as a master's degree or higher, such as a PhD, or if you don't have an advanced degree, you need a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in your profession. Or if you don't satisfy that requirement, you need to convince the government that you have exceptional ability in the sciences, the arts, or business. So how do you show the government that you have exceptional ability in your field? The government lists several criteria. So they give a list of criteria, and you need to satisfy at least 3. Generally, the way we approach applications is to try to satisfy as many as we possibly can, so that if the government decides, we don't actually agree that you satisfy 5 of the criteria, we think you only satisfy 4. Well, you have 4, which is higher than 3, so that is good. If you only apply with 3 and the government disagrees on one of them, then if they're successful in their arguments, you don't satisfy. So it's good to go in strong, try to hit as many of these criteria as you can, and obviously provide the best evidence you can. This is an opportunity for you to really think broadly and to be your own advocate. We as immigration lawyers cannot know what awards you've received. We cannot know what media has been published about you. So it's up to you to think, if I am going to present myself in the strongest way possible, what in my professional history can I point to show that I really am of exceptional ability? So let's get into those categories of evidence or the criteria. So the first is that you have an official academic record showing that you have a degree, a diploma, a certificate, or similar award from a college, university, or other institution of learning relating to your area of exceptional ability. So if you have a degree that's in your field, then that can count as a criteria. Letters documenting at least 10 years of full-time experience in your occupation. So again, if you have a bachelor's and 5 years, you can use that to satisfy the threshold requirement. But if you don't have a bachelor's degree, you can turn to the 10 years of full-time experience. And you do need letters from past employers that are actually signed by those employers attesting to the fact that you actually do have those 10 years of full-time experience in your occupation. Third, if you have a license to practice your profession or certification to practice your profession or occupation. Next, evidence that you receive a salary or compensation that is significantly higher than what is standard for your profession. So an area where this comes up is, for example, if you're an entrepreneur. Many entrepreneurs leave school early, don't actually get their degree, so they can't satisfy the degree threshold, the threshold through their degree. But if they're a successful CEO or owner of a business, they may be receiving a salary that is 4 or 5 times higher than the national average for, say, a CEO. So that might be relevant to an entrepreneur. Can also be relevant to other industries as well, of course. And again, what the government's doing here is trying to use these as indicators of whether you really are of exceptional ability. You're not just a typical CEO, you're an exceptional CEO. So that's what you're trying to do here with these pieces of evidence. Next, membership in a professional association. So this is not just paying your dues to the local chamber of commerce. Although if that is all you have, we would probably make that argument. This ideally would be membership in a professional association that requires some selectivity. Either you have to do something in your profession, like have a certain certification, have a certain license to join this professional association, or if the professional association is composed of people who vet applicants and only choose a select few. That's another way to show you are exceptional in your field because your peers have decided that. Next, recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professional or business organizations. So this is your opportunity to really think broadly. If you need to make the argument that you are exceptional in your field, what people in the government, in your university, your profession, your field, would be willing to write expert letters saying that you actually are exceptional in your field. Similarly, are there any publications? Is there any news media showing that you have made significant contributions to your industry or your field? Again, this really is a category where you need to think broadly because you are most familiar with what in your profession will show that you are of exceptional ability. These expert letters that I mentioned really can be key to a national interest waiver petition. We do spend significant time with our clients helping them think about who those experts might be, as well as reviewing the letters themselves and making sure that the letters are showing how the applicant is exceptional. So we do regularly do that. It is a part of our services, and we do believe that that is a really important part of a national interest waiver petition. And finally, if you are in a field where the criteria that I listed before don't really apply, then the government does say that you may provide other comparable evidence of eligibility, meaning other evidence that shows that you're exceptional in your field. It's generally best to stick to the categories that I listed if they are available, but this does give us an opportunity to make additional arguments and to provide additional evidence if it's persuasive. So those are the threshold requirements to get you to the national interest waiver, what we call the DANISAR requirements. And those are the requirements that allow you to show that your proposed endeavor, it has substantial merit, is in the national interest, that you as the applicant are well positioned to advance that endeavor, and that finally it would be beneficial to the United States that you receive a waiver from the labor certification. So those are the three DANISAR requirements, and we will go through each of those. So first, you must show in your national interest waiver petition that your proposed endeavor has substantial merit and national importance. So again, you don't need an employer. What you do need is a proposed endeavor. So the first step is to look at your work history, your education, your qualifications, and to define what it is, if you are granted this green card, what it is you're going to come to the US to pursue. So the proposed endeavor could be, I am coming to the US on a national interest waiver to create job opportunities by growing a business that already has dozens of employees, and we are going to expand significantly, creating jobs in economically distressed areas in particular. That could be a proposed endeavor. Another proposed endeavor, I am a researcher on nuclear physics, and I do cutting edge research on that. And I want to come to the US to continue that research, which is in the national interest. So that would be another proposed endeavor. Or I am an artist and I focus on this area of art that is really cutting edge. It is new, and I am a leader in the arts, and I'm coming to the US to stage productions regarding this form of art. So all of those would be proposed endeavors. So step one is really defining your proposed endeavor. Once you've done that, you want to think about how to show the government that this proposed endeavor really is of substantial merit and really does have substantial merit and national importance. So this needs to be beyond doing work in the field, standard work in the field. So if, for example, the entrepreneur example, I think is a good one. If you are running a small business with 5 employees, it is obviously important that you create jobs for those employees, but that is very unlikely to convince the government that you are actually going beyond simply being an average entrepreneur, for better or for worse. So you do really want to be ready to show that your proposed endeavor is going to go beyond simply working in the field you've defined. Importantly, I mentioned before that the term national importance can be very intimidating. the government, and specifically in the Danisar case, and since Danisar, has made it clear that to get a national interest waiver, you do not need to show that you're going to impact, all of the United States geographically. This is not about that. National importance can be affecting a limited geography. It could be creating a benefit for a town, for a city, and that can be sufficient. So don't think you don't qualify just because the geographic scope of your proposed endeavor is not national. Endeavors that have national or global implications within a particular field may have national importance. So, if you are working in something I mentioned, nuclear physics, improved manufacturing processes, medical advances, those can have national importance. One thing to consider is the government puts out publications with some frequency regarding STEM subjects, science, technology, engineering, and math. It also will regularly highlight what it defines as critical or in the national importance. So if you are working in a field that might qualify, it may be worth, and if you work with us, we would do this, may be worth doing some research to find out if the government has itself defined your field as being in the national interest. That can certainly strengthen your petition. The benefit of your proposed endeavor must go beyond your immediate employer or client. So again, this is particularly relevant, I think, in the business field where if your impact is really just your business and creating jobs or benefiting your direct employer, that is a hard sell. So you do want to think about, how do I expand and make it particularly clear that this is in the national interest. So if you are working on a business and it's creating a significant number of jobs and it is impacting an economically distressed area, or maybe your job is creating a product that is in the national interest. Maybe it is working on a new form of agriculture that's going to make food available to people, make food safer. These are ways that you can kind of, expand the proposed endeavor and make it clear that this is not just impacting my employees and my direct clients. We really are changing some aspect of our field, our business, our economy. So substantial merit, it tends to be easier to show substantial merit than national importance. But again, we are happy to work with you and our clients on making the strongest arguments possible. So I would say for both of those terms, don't make them more than they actually are. And I would recommend, if you do think you qualify for a national interest waiver, it's worth scheduling a consultation so we can talk through how you might qualify. If we look at the second to the last bullet here, there is a lot of chatter about pilots qualifying for national interest waivers because of well-publicized job shortages. Jiyae can talk more if anyone has questions about pilots applying for national interest waivers. But the fact that there is a job shortage in and of itself does not qualify someone for a national interest waiver. So you do want to show more in your application than just that the US needs pilots. I am a pilot, therefore I qualify for a national interest waiver. All right. And again, there are cases we can point to that get into the nuances of what national importance as well as substantial merit actually mean. Requirements 2 and 3. So requirement 1 is about the proposed endeavor. Is it, does it have substantial merit? And is it in the national interest? The second requirement is about you as an individual. Are you well positioned to advance that endeavor? So this is where you want to provide evidence showing your background. Do you have years of experience working on this? Do you have a degree that qualifies you to do this? Have you published papers? Have you successfully operated businesses in the past that have created jobs and really impacted your local economy? Do you have a track record of success? Do you have patents to your name if you're working in industry or in the sciences? Is there intellectual property that has value that you or your business own? Have you actually started making progress on your endeavor? If you're a researcher, are you already in the US teaching courses on this? Are you employed at a prestigious lab or university to do this work? If you're an entrepreneur, do you have a track record of running a business or businesses? Has the US government shown an interest in your work or local governments shown an interest in your work? If so, are they willing to provide letters, expert letters saying that you really are the person to run this endeavor? We believe in you. We've worked with you in the past. And if you do get this green card, here's how we'll work with you in the future. Those can be very convincing forms of evidence. If you are applying as in the business field, do you already have contracts? Does your business have contracts? Are there tax returns that you can provide that show payments to employees, revenues, profits, et cetera? Again, we as immigration lawyers are not experts on your profession or your industry. We're experts on immigration law. We're experts on knowing what the requirements are, but we work with our clients who can help define. In my field of nuclear physics, here's what is prestigious. Here's how you know if someone is exceptional or not. And we will work with them on gathering that evidence and typically, again, working on expert letters from experts in the field who can speak to the individual's ability as well as the proposed endeavor itself. And I'll quickly add, since it's related to what I just said, that expert letters will oftentimes, it's not like you get an expert letter for requirement 2, and then you get an expert letter for requirement 1. Expert letters will oftentimes touch on all 3, or at least the first 2 of the requirements. It'll talk about why your proposed endeavor really is critical, substantial merit, national importance, and it will also talk about why you are the person to pursue that endeavor. So, expert letters really can touch on multiple aspects of the application. Finally, the third of the 3 DANASAR requirements, the parts of the DANASAR test, is that you show that it would be beneficial to the United States to waive the requirements of a job offer and labor certification, or the PERM process. So typically, this requirement follows naturally from the other 2. If you convincingly show that your proposed endeavor is in the national interest and has substantial merit, if you show you are well positioned to advance that endeavor, then you typically are able to show essentially automatically that it would be beneficial to the US to waive the job requirement. So oftentimes in our applications, we will cite back to prong 1, prong 2, requirement 1, requirement 2, and say, therefore, you should waive the labor certification requirement. I'll mention quickly entrepreneurs. DANASAR does specifically talk about how entrepreneurs, it is natural for them to need to waive the labor certification because you don't test the labor market for entrepreneurs. Entrepreneurs tend to create jobs rather than to compete for jobs. And it's nice that DANASAR explicitly notes that, and you can cite to that in the petition. With that, I am going to pass it off to Jiyae to speak to a little bit more about the national importance requirement. So Jiyae, go ahead.
All right, thanks so much, Dustin. Yeah, so let's talk a little bit about national importance, which is kind of an elusive concept. It can be an elusive concept because the definition of national importance can really mean so many different things. So let's talk a little bit in more detail about what kinds of endeavors are likely to, have a strong argument for national importance. So the thing to note when you are preparing an NIW application is that what is important is showing the importance and impact of the individual's specific proposed endeavor, not necessarily the importance of the field or the occupation the individual will be working in. So, a couple of examples that can illustrate this. So, if you have a proposed endeavor that is very vaguely defined, such as, oh, I would like to, work on developing my business, but you don't really go into detail on what the business does. And then if you, pair that with very general industry statistics about how it is important to, have small businesses that is contributing to the economy on a large scale or things like that on a very general basis, that's not really going to be a very strong claim for national importance because the focus of the importance argument is not on the individual's specific business project, but rather you are trying to make the importance argument through arguing the importance of the industry or the group of small business owners as a whole in the United States. And that's not going to be a very effective way. Another example is what we discussed earlier with regards to pilots. If your proposed endeavor is just limited to, oh, I'm going to come to the United States and work as a pilot, and if that's the end of your proposed endeavor, and if you try to pair that with evidence regarding how important aviation is as a field to the United States as a whole, then that's not going to be a very persuasive claim for national importance because the importance argument is centered on the importance of the field or the industry, not necessarily your particular work, your particular individual work in the field. Similarly, if you're someone who's working in AI, right? And if you provide a proposed endeavor that is very vague, and if you argue something just like, oh, I'm going to come to the United States and work on developing AI, but if you don't go into further detail, and if you try to argue national importance by linking it with government industry proclamations that, generally say that AI is important for the United States competitiveness, then that in itself may not be enough to really support your individual petition for NIW because the argument for national importance must always be very specifically tailored to what you will be doing in the field. So, for example, to discuss more positive examples, if you are someone who's developing a new technology in AI, for example, if you're developing a methodology that will make AI model training a lot more efficient and faster than existing training approaches for AI, and if you are proposing to develop this technology, and not only will you use it for yourself, but you will like present it in industry conferences, and you will, maybe patent this technology, or maybe you will write papers regarding this new technology and disseminate this knowledge through journal articles and other channels like that, then that specific research project that you are proposing to do in the United States has a very specific impact, very, very specific impact that can be, expected from your particular work, which is more than just, proposing that you will continue work in a very important field. So that's the kind of strategy that we try to find with clients, very much tailored to what they will be contributing to the field in their specific niches, in their specific areas. So, in developing this argument, expert letters can play a very important role, and Dustin alluded to this in the previous slides. But this is important because experts can provide the background of what is the limitation that the field is currently seeing. And expert letters can also provide more flesh and bone into, more materiality and concrete detail into what you are specifically planning to do in the United States that go beyond simply just working in the field, just, using, existing approaches and doing things. But what is the plus alpha? What will you be coming in to do and contributing something that is original that will change the way that things are being done in the industry? And even if you're not a researcher, even if you're in the field of business, maybe you're bringing in some original concept in your particular field of business that will provide kind of a new role model for how things can be done. So, for example, if you're in, an agricultural technology business, and if your particular way of designing agricultural facility is more, environmentally sustainable and more efficient and more safer than other methods that are particularly, in use right now, then what you will be doing in the United States is not only, creating profit for yourself, but you're actually contributing to the advancement of that particular technology in agriculture, that particular niche in where you are operating your business. So you can argue a broader impact through commercializing this new approach. And expert letters can really provide a lot of concrete detail and the explanation about these things. And it is more persuasive because it is not only you who are mentioning these benefits, but other experts in the industry who can confirm that your idea does have this potential. So, and even better if you can get expert letters from people who are involved in government, such as, if you're in agriculture, maybe you can get an expert from the USDA who can testify to, how this new initiative can really help improve the way agriculture is being done. If you are, someone who's developing, I don't know, new research in aerospace technology, then why don't you, try to get an expert letter from someone who's affiliated with NASA, who can talk about the transformative impacts that this technology can have to many different scientific purposes. So expert letters can provide that level of objective confirmation of the transformative potential of your work that can be very effective for national importance. So as we mentioned also in earlier slides, if your work tends to only benefit one specific employer. So if you're coming in as a professional and if you'll be employed by one company, and if your work will only tend to generate profit for that one company, that will usually be considered more like a localized impact, which is not a very strong claim towards national importance. To meet the NIW standards, the government is looking for broader benefits than that go beyond benefits to one specific employer. The localized benefit. So what we're really looking for is how can you present a proposed endeavor that, where you can expect broader impacts to either a field or a particular region or the public at large. And there are some examples that the government has given in the USCIS policy manual that can provide a little bit, more concrete detail about what kinds of things that they're looking for. So for example, the USDA's policy manual mentions a person developing a drug for a pharmaceutical company, which may establish national importance by demonstrating the prospective public health benefits of the drug instead of solely projecting the profits that will accrue to the employer. So here we can see that what the government is focusing on is the broader impact to the public, as opposed to just generating profits to one particular employer. Similarly, if you are someone who's working in technology, if you can show widespread interest in your industry in adopting or licensing a particular technology because it has some innovation, if you're developing a novel or important manufacturing process that others can also follow and implement in their own factories, or if you can show how the particular technology that you're working to develop stands to impact the development of similar technology within other companies. So if you can show that your business or if your particular project is kind of a front runner of some sort in the industry that can show the way for, a broader change within the field, that kinds of endeavor would have a stronger claim to national importance as compared to endeavors that tend to benefit only a localized benefit, such as to your own employer only, and does not have a spillover impact to other companies. Finally, one thing to mention is if you're an entrepreneur and if you're creating substantial economic benefit to a particular region with creating U.S. jobs at a very significant level. And this by we mean hundreds of jobs. It will definitely have to be more than, the average number of jobs that a small business would, you would likely see at a small business. We're looking at a much larger scale of an economic endeavor. And if you can show that that level is significant with respect to a population or economy of a particular region, then that entrepreneurial endeavor could meet the national importance standard. And here it is important to also provide data about where the business will be located, because if you can show that the business will be creating hundreds of jobs in a particular area where it is more economically depressed, for example, maybe it is a rural area with only 1,000 people in, a couple thousand people in the region. So if you're, developing a high number of jobs in that kind of region, maybe the impact will even be larger because of the particular economic circumstances of that, rural or remote region. So definitely, this is a very fact-specific inquiry. Please get in touch with us, and we'll be happy to, look at your profile and provide our assessment of the claim for national importance. All right, so then now let's shift gears a little bit and talk about what is usually included in an NIW submission. What is kind of the documentary package that we would prepare with the clients. So in the NIW submission, the first thing that you must include is proof that you meet the threshold requirement for the EB2. And Dustin went over this in great detail in the previous slides. But there are a couple of different ways you can meet the threshold requirement. And so if you're meeting the threshold requirement through showing that you're an advanced degree professional, which is defined as a master's degree or above, or if you're qualifying with a bachelor's degree in your field with 5 years of progressive work experience, what you will want to do is to provide the proof that you have the degree. So if you're qualifying with a master's or higher, then you would provide the diploma copy, transcripts from your school that show that you've completed that and actually earned the degree. If you're qualifying with bachelor's plus 5 years of progressive work experience, you will need to also prove that experience. So what you will do is you will collect letters from previous employers that not only describe how long you worked and, from when to when you worked, but also will describe your specific job duties. And the important thing with the progressive work experience letters is that they must describe how your duties changed over time to include, more complex duties, more senior responsibilities, and maybe your job title change from, maybe a junior, engineer to a, senior engineer, then maybe to a principal engineer. So if you can show that progression upwards in your career, that kind of evidence will be positive in proving that you have 5 years of progressive work experience, because USCIS is indeed looking for that change. One thing to know, very important, is that if your degree is a foreign degree, so if it is a non-US degree, it is very important to also get a report from an education equivalency assessment organization to certify that your foreign degree is equivalent to the same level of degree in the United States. Without that, you may not be able to qualify as an advanced degree professional, because you do need to show that equivalency. And there is quite of a bit of a complexity in there as well, because not all countries have the same educational system with the United States. So it is very important to try and get this evaluation in advance to confirm that the degrees are actually equivalent. So on the other hand, if you are meeting the threshold requirement through showing that you have exceptional ability, and we went over the evidentiary criteria for the exceptional ability, and you do need to show at least 3 out of the 7 criteria that we talked about. So if you're doing that, then it is important to make sure that your document package includes evidence actually meeting 3 out of the 7 criteria. So, for example, if you're submitting that you have 10 years of full-time experience in your profession, then you will need to gather, letters of confirmation from previous employers that tend to show 10 years of experience. If you're trying to meet the criterion recognition for your achievements by your peers, by government or professional associations, then you will provide evidence of that recognition, either through expert letters or through, other objective things like awards, certifications, certificates of appreciation or things like that, or media mentions of you and your work. And a lot of these evidences can actually overlap with the evidence you could use in support of the national interest waiver, which is the next part of what an NIW submission includes. So the major part of an NIW submission will be materials that tend to support that you qualify for the NIW under the three-prong matter of DANISAR standard that we went in length in the previous slides. So that includes the fact that your proposed endeavor has substantial merit and national importance, the fact that you yourself are well positioned to advance this endeavor, and third, that on balance, it will benefit the United States to exempt the labor certification requirement for your particular case. So in support of national importance, for example, a very important thing will be to provide a statement, concise and persuasive statement of your proposed endeavor that shows the government what you're planning to do in the United States that is beyond just proposing that you'll be working in the field. If you're an entrepreneur, for example, it can also be very helpful to include a comprehensive business plan that will show the government what you're planning to do, what kind of limitations in the industry are you addressing, and how will your business improve the way things are done in your particular field. Government reports and academic papers or other background information can be helpful in contextualizing the field and contextualizing what your project will be doing, and supporting the impact that your particular project will have. But keep in mind that all of the evidence should really be focused on the impact of your project in the field, not necessarily the field where you'll be working in or just the importance of the occupation as a whole. Now, expert letters is also a very important aspect of, with regards to evidencing either the national importance of your proposed endeavor or the fact that you're well positioned to advance this endeavor. And you can get letters from leading authorities in your particular field to provide that detail and context, or it can also be letters from someone affiliated with a government agency. So if you're an entrepreneur and you're creating a high number of jobs in a particularly economically depressed region, maybe you can get a letter of support from the mayor, or you can get a letter of support from, a local city official, someone who's invested in economic development in that particular region and is affiliated with the government. Letters from people like that can really help give the petition a leg up in the NIW petition. The applicant's resume, degrees, and proof of professional accomplishments, that can really be the portfolio that you provide to the government to support the second prong that you're well positioned to advance the endeavor. Because what the government is looking for is a record of success in related projects that they can rely on to think, okay, given that this person has done so many impactful things in their field, it is reasonable to think that this proposed endeavor will also be successful. If you're an entrepreneur, you can try to rely on special forms of evidence in the industry, such as proof of contracts, letters of intent, and evidence that you have startup capital to show that you have the traction to drive the project forward, and also to show that the endeavor is a real one and it is likely to succeed. It can show progress towards advancing the endeavor, which is another way that the government looks at in terms of whether you're well positioned to advance the endeavor. If you have a business idea, for example, and if you were accepted in prestigious incubators or accelerators, for example, like Y Combinator, Techstars, or things like that, that in itself can also be persuasive evidence towards the fact that both that your project may have national importance and also that you're well positioned to advance the endeavor because you already received that kind of evidence of traction in your startup idea. Other evidence to show that the labor certification can be waived. Again, in the national interest waiver petition, a lot of the evidence can serve multiple functions, such as, Dustin mentioned the expert letters can have helpful detail for either the national importance prong or the well-positioned prong. So really, a skilled advocate should be able to use many different forms of evidence in your profile to support all three prongs of the NIW, and also maybe exceptional ability as well. All right. So we can move on to the next slide. So let's discuss a little bit about some recent trends and strategies. So the first thing to mention is that there has been a very remarkable increase in the number of NIW cases that have been being filed to the government. In 2018, the number of NIW cases filed per year was only around 8,000 cases. And by 2023, it rose to around like 39,000 cases, which is in itself a five-fold increase in only 5 years. And in 2024, I believe this almost doubled as well as compared to the previous year. So now it's more like 40K, 50K or something like that per year. And that has definitely impacted how the government is looking at NIW cases. And so we have seen, and this is kind of a tendency across the board, an increased rates of RFEs, of requests for evidences, and denials, which means the government is looking at NIW cases in a much more stringent way of adjudication. Also, the government recently issued some policy guidance in January 2025, which clarified several aspects of qualifying for an NIW, which may or may not change given the change in administration. Policies can change pretty quickly within USCIS, so we are monitoring any movements with regards to the NIW. We haven't seen anything up till yet that is that has come down so far, but definitely this is something that we're keeping an eye on. One thing to note is that there have been some positive changes with regards to the policy of how entrepreneur cases are adjudicated, which was promulgated a couple of years ago, and it is a lot of it is still relevant in the newest policy manual, so these are still relevant today. But the things to note is that if you're an entrepreneur, there is a variety of other non-traditional forms of evidence you can use to support the merit and importance of your work, such as media attention on the self-petitioner, the business, or both, any awards or grants received from government entities, letters from third-party industry actors such as VC capital funds or external investors, for example, which can support the national importance of the endeavor by providing more context to the expected impact of the business project to advancing the field more broadly. Letters from government agencies can be particularly helpful in meeting the national importance prong. Evidence of revenue generation, growth, and job creation may be used to support substantial merit of the person's business endeavor, or national importance if the job creation was in an area that is economically depressed. So definitely there is a way to maneuver around the types of evidence you may rely on to support the NIW prongs if you are an entrepreneur. Similarly, well-positioned can be supported by, factors such as ownership and critical role in the U.S. entity. And again, a lot of these evidences also overlap with one another. Government grants, for example, can also provide support for well-positioned because it means that you were able to, achieve that traction through your exceptional entrepreneurial work. So those kinds of evidences can be helpful on multiple prongs. All right, so then now let's shift gears and talk a little bit about timing and other strategic considerations when you are moving from a non-immigrant visa, such as an E2 visa, an O1 visa, or things like that, to an NIW, which is an immigrant petition. So let's talk a little bit about timing. How long does it take to obtain a green card through the EB2 NIW process? So premium processing is available for the underlying petition, which is the I-140. That is the main petition that you submit to the government to show that you are qualified for a green card under the NIW category. For that one, if you use premium processing, you will get a decision, either a decision, a request for evidence, or a notice of intent to deny. The government will provide some sort of action within 45 business days. And if you use regular processing, it means the petition will be pending for around a year. However, one thing to note is that filing the I-140, which is the underlying immigrant petition, is not the end of the story, because even if you are found to be eligible for a green card and with the approval of the I-140, you need to wait until what we call, your priority dates become current, in order to be able to file for the next step of actually getting the green card through either an immigrant visa or filing an I-485 adjustment of application, adjustment of status application, through USCIS if you're already in the United States. And that can take a while because right now the EB2 category is backlogged, which means more people are eligible and applying for a green card under this category than there are visas available every year, which means there is kind of a waiting line, like a first come, first serve arrangement where you will need to wait probably around, between 1 to 2 years before right now, before you can, you can reach the front of the line to file for an actual green card. So if you look at the entire timing from the moment you file the NIW petition to the moment you get your green card in hand, that can be quite a long-term process spanning several years. Another thing to note is that if you are currently in a non-immigrant visa status that does not allow for dual intent, such as, a TN visa, for example, or an F1 student visa, for example, once you file the I-140, it may be more complicated to renew the visa or extend the visa at a consulate, for example. This is a kind of a fact-specific area with regards to the type of visa that we're talking about. So definitely get in touch with a lawyer if you'd like to discuss more about the risks that come with expressing immigrant intent in that way when you're on a non-immigrant visa. Certain types of visas are not affected by that, which are called dual intent visas, such as an H-1B visa or an L visa. Those are understood as dual intent visas. The O-1 visa is also more lenient in terms of immigrant intent risk factors. So definitely it depends on your type of visa. So the application process, I did go into a little bit of detail about this already. So you would submit the form I-140, that is the underlying petition, showing that you meet the requirements for the EB2 NIW qualifications. If the category is backlog, you must wait until your priority dates become current before you can move on to the next step, which is filing the I-485. Or if you're not in the United States at that time, you can file an application for an immigrant visa, and then you'll do the landing as green card holder after your immigrant visa is approved. But that can also take some time to process. Is the EB2 category current? It is not current at this point. So there is that backlog where you will need to wait over a year, given current conditions. This can improve, or it can get worse. It really is something that we keep an eye on regularly, and it fluctuates as the demand for green cards fluctuates. And it also depends on your country of birth. So definitely get in touch with us if you'd like to get more detail about that. Pros and cons of adjusting status in the United States versus consular processing. If you are already in the United States in a different non-immigrant status, you have the ability to change status, adjust status to a green card holder while in the United States by filing an I-45. If you do that, you could get a period of time where you're basically stuck in the United States. Because once your I-45 is pending, you can't really travel outside of the United States if you don't have a travel authorization form without abandoning the application. So, but if you don't have that worry, if you're able to, kind of stay in the United States for a little bit while your status is being adjudicated, then it could be a good option because you don't need to maintain an underlying status in order to continue living and working in the United States while your I-45 is pending, especially if you also apply and get approved for employment authorization card and EAD, which is pretty much an open work permit that will allow you to work for anyone in the United States. Consular processing preserve this freedom of travel. You're basically saying that you will apply for the immigrant visa through your home country consulate and go through the immigrant visa interview at your home country and come back to the United States on the immigrant visa. You can do that if you prefer to stay outside of the United States, or if you, feel like you want that freedom to, travel in and out. That can be a good option for you.
Great. So, Jiyae, I'm looking at the clock. I think we're up against time, and we have received a couple questions. So,
All
the
right.
first is related to what you were just talking about. Does changing, I think they mean adjusting status in the U.S., so applying for the green card from within the U.S., affect the I-140 application? I'm not sure exactly what the question is, but I don't know if you have thoughts.
Right. So, change of status of non-immigrant. So the I-140 application, you can really, that's the first step of the NIW petition. You can do that from abroad. It doesn't really matter what status you're in right now when you're filing the I-140. You can file the I-140 at any time. Now, what we are worried about is once you file the I-140, that in itself can also be taken as a form of immigrant intent. So if you're filing the I-140 and then after that you try to apply for a visa from a consulate, for example, that is a non-dual intent visa, such as a TN visa, for example, you could get a little bit more questioning on what your real intent to the United States is. Is it to immigrate, or is it to, work on a temporary basis? So that can definitely have a little bit of impact. But yeah, talk to us if you'd like to discuss in more detail, because it does depend on what kind of visa you're applying for.
Perfect. And then the last question is regarding executive orders, any impact on NIWs that you've seen?
Right. So the thing that I would mention regarding the executive orders is that some of the executive orders revert or cancel the previous executive orders that some people may have found favorable in building their national importance argument, such as things about AI or STEM, for example. So the effect of that is that when you're building your NIW argument, maybe don't rely on old executive orders that have been reverted, but more like, focus more on the impact to the field, kind of in the more industrial way. So it can definitely inform what strategies we use in building the national importance argument for sure. But yeah, it'll definitely be a fact-specific inquiry when we prepare a case.
Perfect. And finally, yes, we do. The question is, do we assist with responding to RFEs, requests for evidence? Yes, we do. We help people do that. So if you're interested, please do schedule a consultation. Jiyae, thank you so much for the great information to our audience. Thank you for the great questions. Do keep an eye out for that email, and we hope to see you on future webinars. Thank you all so much, and stay well in the meantime.